Hello and welcome to Franczek PC's monthly education webinar series. I'm Scott Metcalf and I'm here with my partner, Dalianis. Today we're going to discuss some of the top financial and operational issues facing administrators and board members right now. The school year ending, summer projects starting, and districts already preparing budgets for the next school year. This is a great time to consider some of the construction issues, tax collection issues, and budgeting issues that you'll be confronting over the next couple of months. We're happy so many of you have joined us today. We have some things that we want to talk about, but we want this to be as interactive as possible, so we welcome your questions. Please try to share your questions in the Q&A section though. It's easier for us to see the questions there, and it's better for us than if you try to go into the chat section where we might miss the questions. And we'll do our best to answer all of your questions as we go along. The first topic that I thought that we would discuss today are some of the construction projects that are going on across almost every one of our clients this summer. You know, every year, once the students and teachers are out of the classrooms, work on the physical plant starts. And the summer construction window keeps everyone who works year-round at a school district busy, even though classes aren't in session. And right now, a lot of people are just starting to hear about a concrete strike that started last week, actually. Local 150 of the International Union of Operating Engineers went on strike on June 7th. So this is going to affect the concrete suppliers, Lehigh Hansen, Vulcan Materials, and Lafarge Holcomb, who supply the vast majority of concrete for the construction projects all across the state of Illinois. In fact, they're the three biggest construction material producers in the entire state. And I've heard from two districts already that this is already starting to cause delays in some of their projects. The number of loads of concrete that you're going to be able to get is dramatically reduced. And hopefully this strike will be alleviated in the very near future. But it really raises the question, what do you do in a situation like this, where there are going to be delays that are outside of the control of your general contractor or your construction manager? Well, the first thing you of course have to do is look at the contract. In other arenas, I've described the construction contract as the prenuptial agreement of this area of the law. It's entered into when everybody is happy and looking forward to a great project, but the contract terms all deal with what happens if something goes south. And most of the time, nothing is going to go south. But if it does, you want to have a good construction contract to protect your interests. So if there are going to be delays because of a construction or a concrete strike or some other issue, you have to look at your contract terms. One of the first places that people look to is whether or not they have a liquidated damages clause. Now, in a situation like this, where the delay is going to be largely outside of the control of either your general contractor or your construction manager, liquidated damages really aren't appropriate. They are more appropriate when the delay is caused by either the general contractor or the construction manager or the subcontractors not providing sufficient manpower, and the delay is really the result of their inaction. So, you know, change orders are not great. What you'll ultimately have to do, in all likelihood, if the delay is going to be longer than 30 days, is look to doing a change order. And change orders are one of those things that are provided for in standard contracts, but they're also governed by state law. And that state law is not in the school code, it's actually in the criminal code. There's a criminal code provision that applies to change orders. And it applies to any change order that's going to increase or decrease the cost of a construction contract by more than $10,000. Or, and importantly for the situation of delays, increases the time of completion by more than 30 days. So if this strike lingers on and your going to have to extend the time of completion by more than 30 days, a change order is the appropriate mechanism to do that. And what you need to have is a statement from pretty much your Board of Education, unless they've delegated that authority to someone else, stating that the circumstances that necessitate that extension of time were not reasonably foreseeable at the time that the contract was entered into. And of course, most of you are probably thinking, well, the problem is my board does not meet over the month of July. So in instances like that, where there's a change order either for extension of time or to increase or decrease the cost of a project comes up in July, the best thing is to already have had the Board of Education delegate some of their authority to approve those change orders to someone who is on site. So those are the sort of the change order issues that people are going to be looking at over the next couple of months. But the other really important thing for school district officials to focus on right now is checking of the work, because someone is always supposed to be checking in on whoever is doing the work to make sure that it's being done correctly and in accordance with the specifications. That could either be your architect or your construction manager. Your architect's contract in all likelihood will say that they are only going to be coming out once a week to do a site visit to make sure that everything is going according to plan. A construction manager, on the other hand, is more likely to be there on a day-to-day basis. So you get a little bit better supervision, but ultimately it's a team effort amongst the school district personnel in charge of the construction project, as well as the architect and the construction manager, to really look at what's going on a day-to-day basis to make sure it's being done correctly, because it's much easier to correct an error now, halfway through the project, than it is at the end of the project, when you might have to open up a wall to redo the wiring or some other major issue that has to be corrected. It's better to do that now and to know about it now. But those are the construction issues really that are going on that we're dealing with right now. But Eris, I know there's a couple of pieces of legislation that have passed recently that are also very important, and they affect more of the tax levy and collection process, as well as the budgeting process. The first one was just signed into law at the end of May, and it was Public Act 102-895, dealing with the extension of some authorizations to transfer between operating funds, disclosure of cash balances, and then the PTEL look-back provisions. Can you kind of explain a little bit more about what's going on with each of those?
Absolutely. Thanks, Scott, and thanks everybody for joining us over the lunch hour today. So let me start with the last item in the bill first. So this is something that, I was sort of mildly excited about when I first saw it. I thought it would provide some opportunities for clients. The more I've spoken with clients and the more I've sort of thought about it, my enthusiasm has waned a bit. But it's an amendment to PTEL section 18-190.7. Scott and I did an alert on this that came out about 2 weeks ago. So hopefully you get our alerts and saw our commentary. And it addresses a situation where school business officials, boards are always reluctant to not levy to the max. You want to get the full CPI when CPI was below 5%. You don't want to miss out on new property. You want to just not leave any money on the table that you might regret in the future, because that value compounds over time. So what that results in is everybody is balloon levying, 4.99, let the county clerk add on a little loss factor, and you never really lose out that way. Here, it allows a school board to levy below its max, and in a sense, put that additional levy authority over to the side for a year or longer and revisit it when they choose to do so. So if you are otherwise able to levy at a full 5%, the board might say, hey, we're going to levy at 3%, and that extra 2%, we're going to go and reclaim it in a subsequent year. And so the way PTEL works now is, even if you don't levy at the max in a given year, you can look back 3 years and use the highest of the prior 3 years. This is, in a sense, better than that because you can recapture and reclaim what you haven't levied for in the future. Now, the limitations here are you have to let the county clerk know within 60 days of approving the levy that you want to do this. You have to certify some sort of a statement, and I haven't seen that statement yet. We'll probably end up developing something for clients that want it. That has to be done. And then the other limiting factor, which is fairly significant, is even when you layer on this additional, in a sense, banked authority that you put aside in a prior year, you're still limited by a 5% cap or the greater of 5% or some voter approved amount. So as a practical matter, if a school board were to say to levy at 3% rather than 5%, once the clerk adds on the loss factor, for most districts in Cook, it's at 3% and 5%. It's a lower amount outside of Cook. You're probably going to be at the ceiling anyway, so I'm not sure how helpful this is going to be. So that's why, kind of to revisit my initial reaction, I was like, hey, this is a positive for our clients, something that may be helpful. I think when practically applied and loss factors are applied, it's a little less helpful, but it's something that's out there. No one has been overly enthusiastic about it in my conversations, but it gives you one more tool in your toolkit, something to talk to the board about if they want to make a public statement and levy below where they're actually at.
Plus, I mean, with inflation at or above 5%, we'll have to wait until the current inflationary cycle is over before you could even increase to recapture what you gave up in past years.
That's exactly right. So that's another reason, say, if this bill had come out 10 years ago, it might have been a little more practical and useful than it is right now. But it's out there. We put an alert out, and it's something to think about. Part of this same bill, Public Act 102-895, includes this new provision, which I don't really know the backstory here. It's section 17-1.3, disclosure of cash balance. It appears to be something along the lines of additional transparency for Illinois school district, because it requires you to, at a public hearing at which the district certifies its budget and levy for the year, to provide the cash reserve balance of all funds held by the district related to its operational levy, and if applicable, any obligations secured by those funds. So the only thing I can think of is it's just something where it would allow the community to know how much money a district has available in reserve. And so that is what this section does. I'm not sure what prompted it. There's a lot of other disclosures that's out there. Your AFRs are hyper descriptive and readily available on websites, but somebody in the General Assembly felt this would be a good idea.
Yeah, I mean, I'm just trying to unpack some of this language, Eris. I mean, operational levy, it's not necessarily the best choice of words, but I would assume that's going to be your educational fund, O&M fund, and transportation fund. And, the other thing that I noticed is that it doesn't really give any instruction to school business officials about how this information is supposed to be disclosed. It doesn't say that it has to be posted on the website. So I would imagine that it could just be part of the normal budget presentation that is given to the Board of Education.
I think that's exactly right. And what's interesting is it says at the public hearing at which the district certifies its budget and levy. So you're really doing different public hearings for your budget and your levy at different times of the year, pre-September 30th, and then sometime most likely in December. So in my mind, it should have said or is this, in a sense, creating a situation where you've got to do this 2 times now, once when you certify the budget and once when you certify the levy? So not great legislative drafting, but I would urge you to take a look at it. We've got it in that same alert that we had sent out. And then the final piece here, this is our old friend, section 17-2A. This allows for interfund transfers among and between ed, O&M, and transportation. Requires the board to hold a public hearing. You got to publish a notice in a newspaper, no less than 7 days, no more than 30 days. And this is a section that has been out there for close to 20 years now, but it's always done in 2 or 3 year time periods with a sunset date. So the current sunset date is June 30th of 2024. This law bumped it to 2026. So it buys it a few more years of time. This is a very popular interfund transfer tool that we've worked with clients for a long time, helping them get these done. But this one is now on the books essentially for another 4 years through the end of the 2026 fiscal year. So,
and I think it's always good to remind people the procedures that are involved in doing a Section 17-2A transfer, because it's quite specific in the school code that you need to publish notice at least 7 days, but not more than 30 days before the board is going to act on this. And then the board has to hold a public hearing about whether or not to do the 17-2A transfer. And then the board has to adopt a resolution making the transfer. So these are all steps that you need to think about, you know, a month or two in advance in order to get all of your ducks in a row, to get the newspaper notice published, to make sure that you have the hearing scheduled, and then have the resolution drafted and ready to go. And then, you know, the other thing, Harrison, is that it occurs to me that we've done a lot of work with 17-2A transfers, and then also with working cash fund abatements, and they're very different procedures for the two of them. You know, 17-2A transfers are pretty highly regulated in terms of what you have to do with the notice and the hearing, et cetera. But the working cash fund abatement issue, you don't have to do the newspaper publication. You just have to adopt the resolution transferring to the fund most in need from the working cash fund.
No, that's absolutely right. You got a lot more latitude. That's in section 20-10 that was implemented maybe a dozen years ago, really a reaction to some tax rate objections that Scott and I were heavily involved in, went to the appellate court, won on, and this law provided school districts with a lot more latitude on that kind of a transfer. So yeah, definitely some options out there for you. Some are a little easier, some require a little more planning.
Yeah, well, I'm going to mention another piece of legislation that you and I worked on, which is the recapture levy. You know, last year, the General Assembly finally passed legislation allowing school districts and other taxing agencies to recapture some of the money lost through refunds as a result of PTAB appeals, circuit court cases, and certificates of error. But now, I think the big question a lot of our clients that have been asking you, Eris, is, you know, what do we do with this extra money when we get it?
Yeah, no, it's a good question. And so the question has come up quite a bit. Scott's referring to the new section 18-233 entitled Adjustments, Certificates of Error, Court Orders, and Final PTAB Decision, which is essentially the recapture recovery levy concept that's been out there for a long time. I know, you know, probably going back 20 years, I've worked with the folks at EdRed, Lend, Luda to get something like this going. Finally, last year, and the principal proponent of this on the school district side was Mark Altmeyer, the former IASBO president from the Huntley School District, working with Dr. Jacoby and other folks. But it did get passed. It was signed by the governor August of 2021. And basically, you know, it sets up a procedure where any refunds caused by a certificate of error, by a PTAB decision, or by a circuit court valuation objection, those can be recaptured by the school district. It's an automatic process. There is no affirmative action required by the school board to have a separate line item or to approve it independent of the levy. It is done by the clerk. Now, there's been a few hiccups along the way, and I know all of you are probably hyper familiar with what's happened. The notice of the certified amount of recapture dollars is supposed to be out by November 15th. Different counties kind of hit the mark or didn't hit the mark. The ones I'm familiar with were mostly had it done by November 15th. I would give the gold star to Lake County, where they simply posted an Excel document on the treasurer's website with a hyperlink PA 102-50 or whatever the number was, not 508, 519, and then it had it laid out. Now, Cook County missed the November 15th date by a little bit. They published And then they kind of got everybody all excited by republishing with a letter to all taxing bodies at the end of this March saying, hey, we made a few mistakes in our calculations. For the most part, almost every recapture amount that I saw went down. My understanding, there was an error or a double counting on the certificate of error category of the recapture. And the net result is the amount that taxing bodies, frankly, the amounts that you probably told your boards are going to be less or significantly less than was expected. But again, no actions required unless your board decided to abate that amount, which we are aware of a number of clients that have chosen to do that. My understanding, the clerk reached out and told, you got to get us a new resolution with the new abatement amount so we can do what you want to do. Another little bit of excitement came out of DuPage County, where when the draft levy edit report was sent out, and I'm sure there's a number of folks on this webinar who were sort of living that, they also told you, hey, by the way, we're not giving you a loss factor anymore. So, it used to be a 1% loss factor on all operating funds. Now it's no loss factor and just 1% on debt service. So that caused quite a bit of excitement with Kathy King and the DuPage County Clerk's Office. I know DuPage, IASPO, a number of folks were very involved in that. I think it was ultimately rectified to the satisfaction of most, if not everybody. But it should have been brought up a little bit earlier by the clerk and said, hey, this is what I'm going to do. Please plan accordingly. I believe Will County did the same thing with the loss factor. I'm not aware of other counties that did it, but there may be some that have done that. And then sort of circling back to Scott's question, what do you do with this money? And so I have not seen any particular guidance saying it needs to go in this fund or that fund. We have consulted with a number of the accounting firms that are representing our clients, Baker Tilly, Miller Cooper, and the consensus among the CPAs and us is that the money can go into the fund or funds most in need. You don't need to spread it out pro rata. You don't need to put it in a fund that's going to generate a tax rate objection with excess accumulation by having too much money in that fund. You have wide latitude in terms of where the money goes. So that would be sort of my assessment on what's happening with the recapture levy. What are the current issues? And obviously in Cook, given the delinquency of the second installment, nobody's seen any of this money yet, whereas outside of Cook, it was baked into the first installment and it will be in the second installment as well.
Yeah, I think we're going to hit Cook County tax bills next, but we do have a question. What about transfers from capital projects to O&M? Now, Eris, I want you to jump in anytime here. I'm not aware of any statutory authority that allows a school district to transfer out of capital projects and back into O&M. But under what used to be called the IPAM rules, it is more than appropriate to transfer out of O&M into capital projects if you're working on a depreciable asset. In fact, that's where the money should be spent out of, is capital projects. There may be something that you could do to unwind transfer to capital projects within the same fiscal year, but I'm not aware of any statutory authority that explicitly allows a transfer out of capital projects.
Yeah, I think you hit the nail on the head, Scott. Normally we assist our clients with resolutions from O&M to capital projects, and then the money is spent on a project and it's done. I would say that if there is money that you want to get out of capital projects back to O&M, I would just have the board approve a resolution or take some official action unwinding or reversing the resolution of approving the initial transfer. To me, that seems like a legitimate way of getting the money out of capital projects and back into O&M. And from O&M, then obviously our friend 17.2A allows you to move it all over the place within reason.
But yeah, back to Cook County tax bills. They're just, everyone kind of knows that they're going to be later than they have been in the recent past. We have kind of gotten used to an August 1st due date for Cook County tax bills for the last, at least half dozen years. Before that, tax bills were notoriously late. Now, this year, they're going to be late again. And before we jump into maybe some of the reasons why or what can be done about it, it's helpful to just remember that there's a lot of steps to the reassessment process. First, the assessor's office has to send out all the reassessment notices, and then the assessor's office hears appeals, and then the assessor's office certifies, and they do all of this by townships. And so they will break up townships into a group of about 3 to 6 townships and work on those, and then go on to the next group of 3 to 6 townships. And each time they get to the process of certifying it, then they hand all of the information that they've come up with over to the Board of Review for those particular townships. So the Board of Review will open up an appeal filing period for a group of 3 to 6 townships. Once the Board of Review completes its work on all of the townships, then there are still a couple of offices that have to get involved. The Illinois Department of Revenue has to do their study to determine what the equalization factor or multiplier should be. Then the county clerk has to calculate the tax rates and finalize the tax rates with the school districts and other taxing agencies. And then the treasurer has to print and send out the bills. So, right now, Eris, I think we are just wrapping up the Board of Review session. Is that your knowledge?
Yeah, I would say that would be a charitable way of describing it. There are a number of townships where the evidence filing period is closed. Hearing dates are not yet set. And then once the hearings are held, there will be decisions issued and then a re-review period. So we can see the finish line, but I wouldn't say we're in the final turn just yet.
And based on my recollection from last year, we are maybe 2 to 3 months behind at least where we were last year in the process.
Well, I would say more than that, honestly. August 1 is kind of a pre-COVID concept in Cook. You'll recall that in 2021, the taxes were delayed by the county board to sort of give people a little breathing room. They did essentially the same thing again. And so this is more, as you know, Scott, better than I do, more of a technology issue that is causing this delay. But, everything that I've heard talking to people in the treasurer's office where I have good relationships is likely the bills go out before Thanksgiving, due sometime in December. Worst case scenario, there's a January due date of some type. These officials at the county are hyper aware that you have December 1 bond and interest payments due. They realize that even very flush school districts are going to have problems unwinding illiquid investments, may have to incur some penalties. They want to avoid that if at all possible. So that's the reality of it. Nobody knows exactly, but that's probably a realistic time frame.
Yeah, I sat in on the Cook County Board of Commissioners hearing at which they called in the Board of Review and the assessor's office to explain what was happening and try to come up with solutions. And really, it was an issue of technology where the computers at one office were not talking to the computers at another office. And I know that all the parties are working as best they can, but there's very little that they can do right now to really make tax bills come out any earlier than the end of this year or beginning of next.
Right. So that's just the reality of it. I think the message has gotten out there pretty effectively. Interesting, the message is not coming from the county. It's coming from the Chicago Tribune, the Sun-Times, Crane Chicago Business. I'm not aware of any communication from either the treasurer, the assessor, or President Preckwinkle's office telling school districts and other Cook County public bodies, hey, this is a real problem. Everyone's picking it up from other sources. So.
Well, that brings us to the end of our half-an-hour allotment of time. Thank you all for joining us today. Be sure to join us next month for a discussion on criminal background checks, which will be hosted by Amy Dickerson and Emily Tulloch from our office. And if you haven't already, don't forget to subscribe to our email alerts, and so that you can be informed and also notified about our upcoming webinars. Thank you for joining us today, and have a great summer if we don't see you.
Thank you. Bye.